Sir, I welcome you and thank you so much, sir, for agreeing to devote your time for this academic cause. And I think we will learn a lot from you. So, over to you, sir.
Thank you very much, and it's my pleasure. And I think I should start. Uh, Gautam.
Yes, sir. Yes, sir. Yes, sir.
Okay.
Please.
Okay. So, so the topic which has been, am I audible? No. So the topic which has been assigned to me is a big topic, right against exploitation. That is Article 23 and 24, and freedom of religion, a very important topic from Article 25 to 28. And this cultural and educational rights, that is Article 29 and 30. This slide is only for your connectivity. Only that what I am discussing, only the points at this which article we are discussing, only for that. And so first of all, this Article 23 and 24, that is a very important article under the ambit of fundamental right. So in this Article 23 and 24, the first the Article 23, which talks about the prohibition with regard to this traffic in human beings and beggar, and as well as other form of force. Actually, when we see the bare language of the section, so there are few points which has been mentioned there. And out of this particular article, you will find the word traffic, which is the first important thing which has been mentioned there. That the question arises here: that what is traffic? So, first of all, we will come to know that the section which, sorry, this article is 23, which talks about this vision of traffic in human beings and forced labor. First of all, we will come to know what is this traffic. Actually, this trafficking, you will find that it before the 2013 Amendment Act in criminal law, it was not defined. No doubt there was Palermo Convention of 2000 where this concept has been defined, and in India, child trafficking was defined in the Goa Act of 2002. So apart from this, there was no any such mechanism where there was no any such these provisions which was decided, which was defined. But this after this, in the backdrop of this international this commitment and India's signatory on various conventions. So India passed an Immoral Traffic Prevention Act. Reason is that it has clearly been mentioned that when you will see the article which clearly says about there will be uh, the second part of this article declares that any contravention of the provision shall be an offence punishable in accordance with law. Obviously, this first this important enactment which took place in the form of the Immoral Traffic Prohibition Act, although it was before this particular amendment in 1986, it was known as the Suppression of Immoral Traffic in Women and Girls Act. This has been the major amendment took place in this particular act, and the nomenclature has been changed. And this presently this act is known as the Immoral Traffic Prohibition Act 1986. Actually, you will find that this act is has played a very vital role so far as the to curb this evil is concerned. Reason is that only Article 23 has provided a ground to curb this particular evil of the society, and in the backdrop of that, this particular act was enacted. This act is actually says about different aspects pertaining to the issue of this trafficking. Actually, trafficking itself per se is not an offense unless it is done for any commercial or any business purposes. In this particular act, you will find this brothel home, this prostitution, and other related issues have been mentioned. And there is a special police unit is there, and this act talks about the special mechanism to tackle the issue pertaining to the immoral traffic. And the another point that is the begging is concerned. Actually, this beggar term you will not find it has been mentioned anywhere. But the Bombay Prevention of Begging Act 1959, which talks about the term begging, and this term has been defined there. So these two terms, the begging as well as the trafficking, which is a very important part of this Article 23. And this trafficking, that it is one of the oldest form of problem which is existing not only in India, almost all part of the world. And to tackle that, number of international mechanism have been has come into existence. In number of this convention, India is the party, and in the present form, we have a specific legislation in the form of this Immoral Traffic Prevention Act of 1986. A number of provisions which talks about the different aspects pertaining to the trafficking, how it can be curbed, and there is a one bill which is pending in 2018 that is also with regard to this trafficking related issues. And we will see that so far as the other important aspect is concerned, that is so far as to tackle that issue. There is a specific act is there, but there are certain provisions in IPC also you will find where selling and buying of girl for the purpose of prostitution, specifically certain aspects pertaining to the issue of this trafficking has been exclusively mentioned in IPC. But in the year 2003, after this Nirbhaya incident, a very major amendment took place in IPC as well as CRPC and few provisions in Indian Evidence Act. So Section 370 has altogether been changed, and one insertion, a new section has come into existence in the form of Section 370A of IPC, which talks about the uh, aspects pertaining to the trafficking. So Section 370, which says about trafficking of persons, a very comprehensive definition of this trafficking has been mentioned in IPC in this particular section, and 370A, which talks about exploitation of trafficked persons. Before that, in a very specific form, there was nothing specifically which was mentioned, and there was no any comprehensive definition what will we call the trafficking of persons was a part of the criminal law before this 200 this 2013. Although there were other sections in IPC, just I have mentioned, to purchase or to sell for the purpose of prostitution, certain related issues were there in the part and which is still exists in the part of IPC. So this section 370 and 370A, which is specifically which talks about the traffic. And so far as this particular this Article 23 is concerned, we will see that there are a number of case law where this aspect has been discussed by the courts from time to time with regard to this trafficking and its taking related other forms of exploitations are concerned. So we will see one by one these four important case laws where this aspect of this trafficking and related issues has been discussed by the court. And the first case which I have mentioned here, that is People Union for Democratic Rights versus Union of India. That is an old case of 1982, but this aspect was uh, the scope and ambit of this particular Article 23 was discussed by the Honorable Supreme Court of India in very detail, and the court held that the scope of Article 23 is wide and unlimited, and it strikes at traffic in human beings and bigger and other forms of forced labor. and wherever they are found. And it has been specifically mentioned that it is not merely beggar which is prohibited by Article 23, but also other forms of forced labor. So, beggar is actually a form of forced labor under which a person is compelled to do the work without receiving any remuneration against his will, without any remuneration. He or she is compelled to do a particular act. So, in this particular case, the court has, in length and breadth, uh, discussed the scope of this Article 12 in Vishali versus Union of India and others. That is also a very landmark case, where actually in this case, a PIL against forced prostitution of girls, Devdasis and Jogins had come into discussion. Actually, this Devdasi is a particular form of, you call it, in the name of this custom or rituals, is generally found in South India. That is a particular form of this evil of the society, as well as Jogins. These two are the particular prohibited form, or you may call it very harsh forms of the offenses against can be called the woman is there. So the Supreme Court held in this particular case that in spite of stringent and rehabilitative provisions, results were not as desired, and therefore the court held that the court ordered and called for evolution of the measures by the central and state governments to ensure their implementation. The court called for severe and speedy legal action against exploiters such as pimps, brokers, and brothel owners. All these terms you will find that pimps, brokers, and brothels. This term has been defined. The was amended in 1986. So several directives were issued by the court. Later area included setting up a separate zonal advisory committee, providing rehabilitative homes, effectively dealing with the Dasi system, yogis tradition, etc. So the apex is a highly deplorable and heartening to note that many poverty-stricken children and girls in the prime of youth are taken to flesh market and forcibly pushed into flesh trade. That is a very question mark of our humanity, or we called it we are in 21st century of modern society, but it is still being carried out in utter violation of all canons of morality, decency, and dignity of humankind. And there cannot be two opinions indeed. There is none that obnoxious and abominable crime committed with all kinds of unthinkable vulgarity should be eradicated at all levels by drastic steps. The apex court had demanded an objective multi-dimensional study and investigation into the matter relating to the causes and effects of this event. A very long discussion in this particular case took place, and that's why it is a very landmark case, that is Vishaljit versus Union of India, where the bad traditions, the flesh trade, all aspects were discussed in this particular case. The another case that is also very important, that is with regard to this Vishalji versus Union of India and others. These others, in this particular case, Supreme Court passed an order and directing to make an in-depth study of the problem of prostitution, child prostitutes, and children of prostitutes, and to evolve suitable schemes for their rescue and rehabilitation. Taking note of the fact that children of prostitutes should not be uh, permitted to live in inferno and undesirable surroundings of prostitute homes. The Apex Court issued directions to ensure the protection of human rights of such persons. In this particular case, the court also desired that the ground reality should be tapped with meaningful action imperatives apart from the administrative action, which aims at arresting immoral traffic of women under the Immoral Traffic Prevention Act. So this is also a very important case where the court has this particular case that these judgments have flagged off the importance of the individual's human rights and brought to focus the mandatory role and responsibility of the state in ensuring that such violations do not take place. So these two cases are very, very important where the Honorable Supreme Court has in very detail this particular aspect that is with regard to this uh, trafficking aspects was discussed, and you will find that apart from that, this Bachpan Bachao Andolan case is also, this is in this particular case also the court has discussed about this particular problem which is still existing, and in this Bachpan Bachao Andolan versus this of India, this is a case of 2014, and where the court has also talked about the case of missing child not recovered within 4 months from the date of the and the matter was forwarded to the anti-human trafficking unit. That is also an important unit uh, in each state in order to enable the said unit to take up more intensive investigation regarding the missing child. Actually, this trafficking of human beings, you will find that is it will be called the modern form of slavery problem, and you find that it is the backs of the offenses where in the pretext of uh, by the this trafficking number of other offenses take place, and you will find that it is the worst forms of human violation. So, and the missing children is also has taken place in various years. In the you will find there is a NCRB report which also reveals regarding this how many cases have been instituted, FIR has been launched with regard to Immoral Trafficking Prevention Act, Section 370, 370A, which was inserted in the 2013. You will find that more or less it is existing in some years. It has because a few more cases have, or rather, you will find it is continuously existing and it is not reducing. The number of cases has not been reduced. And when we will analyze the NCRB report of different years, either it may be of 2015, 16, 17, it is. So, this is a serious concern and it is still rampant in our society, and this anti-human trafficking unit which is the part of this immoral traffic prevention act, where the court has said that uh, court has directed that anti-human trafficking unit shall file periodical status report after every 3 months to keep the legal service authorities updated. So, and this particular case here, in very comprehensive manner, the court has discussed all the aspects pertaining to this missing children and child trafficking. So, these few cases, which are very, very important, where these aspects of this human trafficking was discussed by the court, and this is uh, apart from that, there are a number of other cases also, but these four cases, and specifically this Vishaljeet versus Union of India and others, People Union for Democratic Rights and Gaurav Jain case, these all cases are very landmark cases where these whole aspects pertaining to the trafficking and other form of uh, forced labor has been discussed. So I will not go more detailed reason that yeah, I have to cover number of other articles. So because in approximately 2 hours I have to complete. Am I right? This all these articles. So just we switch over to this M. और यू ऑल आर गेटिंग इट? अभी 23 से रिलेटेड जितनी बातें समझ में आ रही है, ये वन वे ट्रैफिक की तरह मैं नहीं पढ़ाना चाहता. आई डू नॉट बिलीव इन दैट. So have you got this, or if you have any confusion with regard to this Article 23, you may ask the question. Gautam, hello, am I
Yes, sir. Yeah.
audible?
Yes, sir, you
हाँ,
are audible. Students who have any
क्वेश्चंस लास्ट.
question, you can use the chat box
हाँ, इस
anytime. Raise your
23 से पूछ
hand.
सकते हैं. My query is that या तो लास्ट में पूछें तो भी I have no issue, or if just know in Article 23 what is trafficking, and any other thing with regard to this particular issue, if you want to ask any question, you may ask. क्योंकि ये सिर्फ उस तरह के मैं शायद समझता हूँ वो क्लास कोई लेक्चर की तरह नहीं है. ये पता होना चाहिए कि ट्रैफिकिंग टर्म क्या है, आर्टिकल 23 व्हाट इट सेज, what are the acts, statutory provisions with regard for tackling this particular issue. So if you have any question, you may ask. With regard to this trafficking and this forced labor, no question. Now we come to this prohibition of employment of children in factories. Actually, this Article 23 that which says that, and this Article 23 prohibits the employment of children below the age of 14 years in any factory, mine, or other hazardous activities like construction work or railway. This particular in which particular article prohibits that child before the age of these 14 years shall shall not be implied. No child shall be implied to work in any factory or mine or engaged in any other hazardous employment. Actually, you will find that this particular aspect of this Article 24 of the Constitution, which is talking about that prohibition, I cannot be the part or cannot be engaged in any employment. Actually, in the case of MC Mehta versus Union of India, you will find that the Supreme Court, children below the age of 14 years cannot be employed in any hazardous industry, mines, or other works, and has laid down exhaustive guidelines how the state authority should protect economic, social, and humanitarian rights of the millions of children working illegally in public and private sectors. Actually, this matter was brought before the court by a public spirited lawyer, you are well aware, MC Mehta, by way of public interest litigation under Article 23 of the Constitution of India. And he specifically told about the plight of the children engaged in Sivakasi cracker factories. You know that is very famous cracker factories. This issue was brought up in the form of this PIA under Article 23 of the Constitution. And the court has discussed about this aspect. And you know that in the backdrop of that, this Child Labor Prohibition and Regulation Act 1986 was passed, and it is the most important law in this direction. That is the Child Labor Prohibition and Regulation Act 1986. I will discuss about this 2016 Act, but it is and in addition to that, you will find there were other enactments which were also passed by the uh, parliament. You will find like factory, the old acts is there, the mines act is there, and there are a number of other acts are there. But in the year also 1996, the Supreme Court has directed to establish has directed for the establishment of child labor rehabilitation welfare fund, in which the offending employer should deposit a fine of rupees 20,000 of each child employed by him. It also issued direction for the improvement of education, health, and nutrition of children. And after this particular enactment, the child, you will find that in the year 2016, that is the Child Labor this Amendment Act took place. You will find that the Child Labor Prohibition and Regulation Amendment Act 2016 amended the Child Prohibition and Regulation Act of 1986, and it has this Amendment Act prohibits the employment of children below 14 years in all occupation and process. Earlier, this prohibition was applicable to 18 occupations and 65 processes. And so this Amendment Act has prohibited totally that a child cannot be employed in uh, any uh, any type of these occupations or processes. And this particular act uh, totally prohibited that child cannot be employed in any type of employment. So this specifically this case of MC Mehta and few other guidelines were given by time to time, and in various other cases, the Supreme Court has given certain guidelines, and in the backdrop of that, and few landmark cases, and the enactment by the Parliament, the Child Labour Prohibition and Regulation Act 2016. That is a very landmark case, a very I would say landmark enactment that paved the way, and finally any form of child labor is now prohibited by this particular act, that is the Child Labor Prohibition Regulation Amendment Act 2016. Actually, these two things that we were discussing, that is Article 23 and 24. These two, as we were discussing, that is coming under the purview of this right against exploitation. And you will find that these two articles, that is very important, and number of case laws are there, few important enactments are there, number of guidelines are there, rules and regulations have been passed from time to time. And by this, to a large extent, it can be minimized. Specifically, you will find in the pandemic, like child marriage has increased, this labor has also, due to the reason of this unemployment and this pandemic condition has increased. Because I was watching in BBC, they were revealing that child marriage has increased, and offences against child has also increased in certain aspects. So this right against exploitation, that is a very important right available. So, but despite enactments and guidelines by the Honorable Supreme Court of India from time to time, but like the trafficking, it is still existing due to several reasons. There are social reasons, there are economical reasons, psychological reasons. Only to enact the law, any problem, which is especially the social problem, cannot be eradicated. We are actually, I will say, we are more expecting from the law. Actually, law will enactments are there. The very glaring example you will find like dowry prohibition. It was passed in 1960. Whether dowry has been eradicated, actually, we are more expecting from the law. Law is should be, but a holistic approach is required, and overall change is required from the grassroots level. Then only we can think that this right can be availed, and the person can actually avail this right, that is right against exploitation. Only by the direction or only by enactment we will see that all the changes are going to take place. It is not possible. There is a need of a very grassroots level to by all the people, by the collective endeavors, we can think this problem may be. So these particular aspects I have discussed in very brief, because due to the paucity of time, I have to cover the two major aspects. That is the freedom of religion and cultural and educational. So in this particular aspect, that is the freedom of religion, that is a very very important, very pertinent part of this fundamental right, the ambit of fundamental right, and this this is touching the different other this particular freedom like secularism, and perhaps it has been taught to you obviously that secularism is the basic structure of the constitution in ASR Bombay versus Union of India. So this freedom of religion is a very important part of this rights which has been given under different articles. So this article which requires to be discussed in very very uh, broader manner. So first of all, we will see about this. We will start from this: what is religion? Then what Article 25 says, and there are a few words like profess, practice, and propagate. These few words which requires to be discussed in detail with the help of certain landmark cases, very important cases, and then we will come to know that in the backdrop of that about the importance of this right to freedom. So first of all, I will say that is religion. What is religion? Number of scholars have elaborated according to their own approach, their own feeling, according to their own uh, way. So actually, the term this religion has not been defined anywhere in the constitution, and no doubt Supreme Court has endeavored to define this particular term in a very in a broader manner. And actually, this religion is a matter of faith with individuals or communities, and it may be in different form. And it is actually a matter of personal faith and belief. So, India is a country of religions where birth of various religions have taken place, like Jainism, Buddhism, and there are a number of religions, religious peoples there. So, this country is where you will find it is not like in another country like you will find in certain Christian countries, Islamic countries. Uh, and India is a country where you will find almost all major religions of the world. The people are residing in India, and due to that reason, that freedom of religion becomes very very vital. And this right is available to all, every person. It is not talking about cities like Article 21, 22. This is available for all. But with regard to the employment, it is available to citizens. Like to contest the election of president, he must be a citizen of India. This is available to only citizens. But there are few rights which is available to all. So this right to freedom of religion that is available to all persons, whether it is he is a citizen or not. So first of all, we will see that what the language of the article says. So Article 25 says about the freedom of conscience and free profession, practice, and propagation of religion. So it says that subject to the public order, morality, and health, and to the other provisions of this part, all persons are equally entitled to freedom of conscience and the right freely to profess, practice, and propagate. So twofold freedom actually it can be called freedom of conscience and freedom to profess, practice, and propagate. Actually, the freedom of conscience is a term which you will find that it is absolute inner freedom of the city. It is actually it's talking about the inner freedom of the person to mold his uh, own relation with God in whatever manner he likes. This very inner uh, aspects, and when this inner this when this freedom becomes, or you may articulate and express in outward form, when this inner part it is conscious, but it is when it comes to its outward form, so it is maybe called to profess and practice the religion. So to profess a religion means to declare freely and openly one's faith, and to practice religion is to perform the prescribed religious duties, rites, and rituals, and to exhibit his religious beliefs and ideas, and which is which has been prescribed by the religious order in which believe a person is the believer. So it is providing the inner aspect is actually the conscience, but when it is comes into outward form, then you will find it is talking about the practice or to profess. So meaning thereby this how you practical expression in any manner it may be like that. So this is a very very important aspect of this right to freedom of religion, and to propagate means that is also very important. Explain and publicize his religious view for the edification of, meaning thereby that it may be called that it is the persuasion or exposition, and which is without, it must be without any war. So you can propagate your particular religion, whatever the guidelines or whatever the instruction or whatever the things which is available or which is the part of your religion, that you may propagate it is by the religious scriptures, by you may call it by describing whatever the religious scriptures is talking about that. But this right to propagate your religion does not give the right to convert any person to its religion. You can propagate, but you cannot. It may be called that it does not give the right to convert another person. No doubt by your whatever the dissemination of this information, whatever you are propagating, and a person by its own free will wants to convert, it is not prohibited, because religion is a personal belief and faith. In whatever the religion you wants to own or you wants to follow, it is totally your choice, your wish. So if a person who has been born and brought up in a Hindu family wants to convert to himself or herself to Christianity, he may or she may. Because after attaining the age of majority, after a long study, or due to any reasons, a person wants to convert himself or herself, there is no problem. But it is under compulsion, or like for only taking a benefit, like in family law. In Muslim law, you have already, under certain exceptional situations, a Muslim may go for second marriage. Actually, monogamy is a gender rule, but polygamy is an exception to the gender. People, due to unawareness, they are not aware. Even majority of the Muslims are not aware the philosophy behind this. So, only for the purpose of marriage, if you convert, as we have studied the case, the Sarla Budgal versus Union of India and Lily Thomas versus Union of India, where this conversion was only for the purpose of marriage. It was struck down by the court that first marriages exist, and first marriage has not come to an end, you will be liable for under section 494, 495 of IPC. Meaning thereby, this conversion, and conversion is a very burning issue which was especially in Uttar Pradesh, in Jharkhand, I have seen, I have, there are a number of persons under, I'm not take it in academic perspective, but I have seen by allurement or by any other way, they have just told that if you will convert then to my religion, certain facilities will be given. Few incidents or under coercion, definitely it cannot be done. No doubt, this uh, this is your personal belief, and it is up to you at what religion you wants to follow the instruction of that religion. And this, so far as this, you know that in this regard, there are several cases where this concept, this profession, practice, and propagation is subject to this, but this right is not unfettered. That is, the first part is saying subject to public order, morality, and health, and to the other provisions of this part. These are the certain restrictions, or you may call it limitations, which has been provided in this article itself. So you will find that, just you will see that there are number of cases. So am I audible? आवाज आ रही है ना? So we will go through certain cases where these aspects uh, has been discussed. There are plethora of cases, but we will discuss only few important cases, which where we, these aspects, the different aspects pertaining to this freedom of religion has been highlighted. I hope that we have studied, but definitely it is required to be discussed here, where this all aspects have been mentioned. Like few cases, very important cases like Bijoy Emmanuel versus State of Kerala. That is also known as the national anthem case. I hope you have studied it, but just I want to highlight that in very brief. Why? What is the importance of that particular case in the backdrop of this Article 25? No doubt, this case was also criticized by various scholars. Actually, in this case, that three children belonging to this Jehovah's Witnesses, that is of the children, these three children that was from the children Christian community were expelled from the school. Actually, the reason was that they have and that's what they did, and they challenged the validity of their expulsion on the ground of in this particular Article 25, Clause 1 of the Constitution. And matter came before the court of law. So, uh, uh, actually, a circular issued by the Director of Public Instruction and made it compulsory for all children in schools to sing the national anthem. They had stood, actually, these three children stood up respectfully when the national anthem was being sung, but they didn't join in the singing of it. They refused to sing the national anthem as, according to them, it was against the tenets of their religions, against their religious beliefs, their faith, which did not permit them to join any rituals except it be their prayer of Jeva, their particular rituals which is observed by them. So the Kerala High Court held that it was their fundamental duty under the Constitution to sing the national anthem, and it held that the people belonging to this religious group refused to participate in the singing of national anthem, and it would have a very bad influence on the other students and the headmistress. So therefore, within the right not to permit them to attend the class until they give in writing that they would participate in the singing of the national anthem in the school, so that the conduct of the children is not showing unqualified respect to the national anthem. So you will find that uh, This there are religious practices which prohibits that you cannot participate except their own these rituals. And finally, on appeal, Supreme Court, where they have reversed the High Court decision, where the High Court has said that this is the violation. But on appeal, the Supreme Court reversed the High Court decision and held that no person can be compelled to sing the national anthem if he has genuine conscious religious objection. There is no legal obligation in India for a citizen to sing the national anthem, and the Article 25(1) cannot be regulated by executive instruction, which has no force of law. By standing up while the national anthem was being sung, the children had shown their proper respect to the national anthem, had thus not violated the fundamental duties laid down under Article 51 of the Constitution. Although this particular aspect was criticized, actually to understand or to know that any particular आवाज आ रही है? Am I audible? हाँ नहीं आ रही हो तो यू मस्ट से। तो ये केस आप नहीं सुन पाए शायद। तो in Muhammad Hanif Qureshi versus State of Bihar, actually in this case, uh, in this particular case, the petitioner claimed that the sacrifice of cows। अच्छा रिपीट कर देता हूँ। विजय इमैनुअल केस को रिपीट कर दूं या मोहम्मद हनीफ तो जो शुरू किया था, देवांग बताइए। फील फ्री। यस सर, नो आई डू नॉट। फिर तो ये बात समझ में नहीं आई। ये कौन सा वाला बिजोई? बिजोई Emmanuel versus State of Kerala, इसका nickname है ये, it is known as national anthem case. Like, the three children who belongs to a particular community of the Christian community, Jevas, they at the time of its national anthem, they did not sing that particular national anthem, and it was definitely objective, and they took the plea and they said that actually in our religion, that, that religion they belong, their religion does not permit to sing any particular song except his own praise of their God, and they were expelled due to the reason for refusing this particular refusing the national anthem, and they challenged the validity under this ambit of this Article 25, one of the Constitution. They said that it is our fundamental right under Article 25, that is the freedom of religion. But they were refused to sing the national anthem. They were expelled. So actually, there was a circular which was issued by the Director of Public Instruction, which has made it compulsory, mandatory, that in every school there must be a particular time in the morning national anthem should be. So actually, but they refused due to their religious belief, and the Kerala High Court held in this case that it is their fundamental duty under the Constitution to sing the national anthem, and here these students denied. So, and it would have a very bad influence on the other students as well as the headmistress, and therefore the right not to permit them to attend the classes until they gave in writing they would participate in the singing of the national anthem in school. तभी उनको स्कूल में फिर से दाखिला लिया जाएगा, उनको जो है रखा जाएगा. But on appeal before the Supreme Court, that has reversed the High Court decision and held that no person can be compelled to sing the national anthem if he has genuine conscious religious objection. There is no legal obligation in India for a citizen to sing the national anthem, and the right under Article 25, Clause 1 cannot be regulated by the executive instruction, which has no force of law because it was an executive instruction. And but it was also explained by the Honorable Court that by standing up while the national anthem was being sung, the children had shown proper respect to the national anthem, and thus it is not violative of the fundamental duties enshrined under Article 15(1)(a) of the Constitution of India. And their conduct didn't amount to an offense under the Prevention of Insult of National Honor, uh, this particular act which regulates the aspects related to this national song, national flag. So, this is accordingly the court directed the authorities to readmit the children in the school and to allow them to pursue their study. And now you got the point. कोर्ट ने इसको किस एस्पेक्ट में एलोबरेट किया, चूंकि their behavior, their gesture, all were taken into account. The another important case that is also a very important case to which needs to be discussed here, that is the case of Muhammad Hanif Qureshi versus State of Bihar. Actually, there is a particular festival among Muslims that is called Eid al-Azha or Bakrid. There is a particular belief among Muslims that a particular Prophet Abraham had performed a particular act, and to remember that this particular celebration takes place. Actually, in this particular case, the matter came with regard to that. Actually, in Bakrid, who can afford, they purchase a goat or which is permissible like camel in various places. Uh, you will find in India as well as outside India, or a particular word like in common way it is used dumba like that. So they sacrifice in particular manner to remember that particular, to memorize that particular uh, uh, things which was happened in thousands of years back. So actually, in this particular case, in Muhammad Hanif Qureshi versus State of Bihar, the petitioner claimed that the sacrifice of cows on the occasion of Bakrid was an essential part of his religion, and therefore the state law forbidding the slaughter of the cows was violative of his right to practice religion. Actually, the court rejected this argument and held that the sacrifice of cow the Bakrid day is not essential part of the Muslim religion, and hence it can be prohibited under clause 2A of Article 25. And it is very rightly it was observed by the court that to offer a cow is not mandatory, it is not the part of the religion. You can offer the other things, the goats, or there are that is called the bakara in general languages, a dumba, there are certain other animals which can be. It is not mandatory. Even this cow is not found in these Arabian countries, in this Asian region, especially in India and other regions, this animal is found. So it is not necessary the basic tenets are the of the part of that religion. And likewise, you will find I have not mentioned this case, but just it came to my mind. Like in the case of this, that is also a very important case. In noise pollution, perhaps you may have studied that particular case. That is the Maulana Muhammad Sayyid Nurullah Barkati Rahman Barkati versus State of West Bengal. Actually, the case was with regard to the use of this technologies, that is microphone, for reciting azan. Actually, these 5 times an azan is recited. It is just it is an alarm that the time is there for namaz. You should come to mosque or offer the namaz in your home. It is the latter development. It is not actually basically the part of the religion in the initial period. At that time, they used to burn certain things. The people will come to know, "Oh, this is the time." So they proposed number of things, but finally it was decided that 5 times an azan will be recited and few Arabic words are recited. Actually, that is actually they say that the God is the Almighty, Prophet Muhammad is a messenger. Come for right work, come for right work, come for namaz, come for namaz. These two times, this is 2 times the same things narrated in the case. The Calcutta High Court has held that restrictions imposed by the state on the use of microphones and loudspeakers at the time of Adhan is not violative of the 5 of the Constitution of India. Reason is that Adhan is no doubt which has been recognized an essential and integral part of this religion, that is Islam. But the use of microphone or loudspeakers are not an essential and integral part. Obviously, microphone is a gift of technological ages and its adverse effect is well felt and all over the world. Especially the question arose regarding the azan in the early morning because there is a restriction in West Bengal after perhaps 10 or 11 p.m. to 5 p.m. or 6 sorry 5 a.m. or 6 a.m. You cannot use any activity either is related to any religion. So, and it was held by the court that it is not only a source of pollution, but pollution, rather it is also a source which causes several health hazards. So, traditionally and according to their religious order, azan has to be given by the imam or the person in charge of the mosque through their own voice, and this is sanctioned under the religious order. अपनी आवाज से बिना without using the mic you can offer you can cite the you can give the azan that is not prohibited. भी आवाज आ रही है क्या? बहुत देर से आवाज नहीं आ रही थी क्या गौतम?
सर सर आशुतोष सर, आवाज नहीं आ रही थी सर आपकी थोड़ी देर।
अच्छा, थोड़ी देर तक आवाज ही नहीं आई।
जी सर,
अच्छा अच्छा, ठीक। तो
अब
इसका
आ गई
मतलब वो
सर।
केस में अब आ रही है ना, तो वो केस लगता है मैं ऐसे ही बोल गया और वो मैंने इधर ध्यान नहीं दिया कि वो
हाँ लग
उसकी आवाज नहीं आई। ठीक है, आई
जी सर,
आई
लग रहा है।
रिपीट दैट आचार्य जगदीश्वरानंद केस।
जी
कोई
सर।
बात नहीं, आई ठीक। ओके, आई गॉट इट।
ओके सर।
ओके, as I have sorry due to this voice problem or technical glitches couldn't listen. तो हमने विजयी इमैनुअल का केस, उसके बाद मोहम्मद हनीफ कुरैशी का केस पढ़ाया, ये तो आपको यू गॉट इट। बट लगता है ये आचार्य आचार्य जगदीश्वरानंद का केस जो है ये आप नहीं सुन पाए ड्यू टू दिस रीजन, वॉइस प्रॉब्लम, टेक्निकल ग्लिचेस की वजह से आप नहीं सुन। सो आई रिपीट in Acharya Jagdishwanand Avdhuta versus Commissioner of Police, Calcutta. That is a case of 2003. Actually, this case is popularly known as uh, Anand Marga case के नाम से famous है. In this case, the Supreme Court has held that this Tandava dance in procession or at public places by Anand Margis carrying lethal weapons and human skulls was not an essential religious rights of the follower of Ananda Marga, and hence the order under section 144 of CRPC, that is used in several occasions, prohibiting such procession in the interest of public order and morality, which was not violative of the rights of under Article 25 or 26 of the Constitution. Actually, this Ananda Marga, it was observed that uh, what they do actually, they participate, in a particular procession, they use such type of activities. So it was observed that it was accepted by the court that is the part of their religion. Even accepting that the dance is prescribed a religious rights for every follower of Ananda Marga, it does not necessarily imply that they have right to perform in public places, like in Muhammad Hanif Quraishi. You can, so far as the slaughter of the animal is concerned, but it has not been mentioned in the religion. It is not the basic you may call it the tenets of the religion that you have to think, or you will have to slaughter should take place only of course. It can be done by the, so likewise that it you can even it is the part of your religion, but you cannot be allowed that you do not have the right to perform in public places. Another important case that is of also a very interesting case in this, that is the Javed versus State of Haryana. That is a case of you will find 2003. This Acharya case is not 2003. I forget. That is a case of 1985, 84, 85. This case is of 2003. That is an old case. In Javed versus State of Haryana, that is also a unique case that there was one rule, that is there was a norm of two children norm for the for a particular post was contested in this particular case, and it was held that it is not violative of Article 25 of the Constitution. Actually, in Javed versus State of Haryana, the Supreme Court has held that Section 175, Clause 1, Clause 11, Subclause Q of the Haryana Panchayati Raj Act of 1994, which disqualifies actually this particular in this particular section, which says and which disqualifies persons having more than two children from contesting election for the post of sarpanch and punch in Punjab, actually violate Article 25 of the Constitution. Actually, this provision was challenged on the ground that it interferes with the rights of the religion incorporated under Article 21 of the Constitution. And it was said in this particular case that personal law of Muslims permits performance of marriages with four women, obviously for procreating children, and restriction thereon would be the violation of the right to freedom of religion, which has been enshrined under Article 25 of the Constitution. The Supreme Court has held in this particular case that this provision is constitutional and the freedom of religion is subject to public order, morality, and health. So the article itself permits legislation in the interest of social welfare and reform. The Muslim law permits marrying four women, but does not anywhere mandates it is a duty to perform four marriages. Actually, there is a misconception among Muslims, particularly if Hindu does not know Hindus about the Muslim law, who are not a law student. It is not. It is commonly you will find it may happen. But even among Muslims, generally you will find if you talk with an illiterate person, because majority of the Muslims are illiterate, you will find they will say, yes, we are free, we can solemnize the marriage more than one. But actually, just I want to elaborate it here because it is also covering the family law aspect and which is obviously touching our constitutional aspects. That it has been mentioned in the Quran, but it is better for you to solemnize one marriage because you cannot do justice among wives. And only in exceptional situations, and there is no any exhaustive list is there, but there are certain exceptional situations you may think for second marriage. For example, just an example, I will cite one or two examples. The first wife is issueless, and with the prior permission of the first wife, you can think for second marriage. In India, till now, there is no mechanism that if any person who solemnizes a Muslim solemnizes a second marriage, so he is not going to be checked, or there is no any such mechanism is there. But likewise, in Pakistan, certain other countries, you cannot think for second marriage. There is a particular council, a particular organization is there under the government authority. They will check it. You will have to present a relation, and they will look into the matter. They will call to your wife, and they will ask what is the reason behind that he's thinking for second marriage. So there is a long process there, and after this, this permission may be granted or rejected. But in India, there is no such reasons there. So people generally think we can go for second marriage. Actually, and the purpose is the for progression of children or for physical enjoyment. Actually, it is not. Only in certain exceptional situations, like first wife is issueless, and first wife is suffering from such disease, you cannot go for cohabitation. You cannot live comfortably. Again, with the prior permission of the first wife, you can think for second marriage because both the marriage will exist, and first wife will also entitled to maintain and to all the whatever the rights available to her, she can enjoy it. So just I have given the example to go for second marriage is not so monogamy is the gender rule and polygamy is an exception to the gender rule. So only in exceptional situation it is permitted. So here in this particular case you will find that so actually in this particular case and no doubt the Islam permits, but actually it is not a gender rule. Only in exceptional situation. So and the Muslim law permits marrying four women, but does not anywhere mandates that it is as a duty to perform four marriages. Such practices which will encourage bigamy and polygamy. So the right to contest election for any office in panchayat is neither fundamental right, not it can be called. It is a statutory right and subject to qualifications or disqualification prescribed by the law. If a person does not fulfill such qualification, can be prevented from contesting election for such. Meaning thereby, uh, whatever the restriction which has been mentioned, the limitation that is public order, decency, These all words which has been mentioned in Article 25. So it can be court can look into if this particular activities or action is coming under the ambit of any of these this subject to this limitation or restriction, that this restriction can be imposed. Like just I have mentioned also the case of Saira Banu versus Union of India. You are well aware regarding that particular case. This is a very recent case of 2017, where you will find that uh, this is the case of triple divorce, and where also there was he was taken. It is a part of the religion that was also uh, discussed, and this question came before the court. Actually, in this case, the Supreme Court by 3:2, you know very well, 3-2 declared that triple talaq, or which is also known as talaqul biddat, is unconstitutional, irrevocable, and unconstitutional, and it does not, it forms no part of Article 25 of the Constitution, because it has not been mentioned in the Holy Quran that a person can pronounce divorce in three times in a stretch or in a single sentence, that I divorce you, I divorce you, and divorce you. Neither it has been mentioned in the Holy Quran nor in the Hadith. Rather, it is the latter development in a particular dynasty, Umayyad dynasty. This concept was evolved, although it was accepted by the Hanafi schools. Majority of the Indian Muslims belong to the Hanafi school. It is not a part of the, and it is not the part of the religion. So if any particular rituals are performed, court looks into whether it is the basic tenets or the basic spirit of that particular religion. Whether it is the part of basic spirit of the religion, that will be taken into account. That is the important. So meaning that by these all cases, the court has taken into account these all aspects from time to time, whether it is the integral part of the religion, that is case of Muslim among Hindus or Muslim or any other religion, any religion. So in different cases, these aspects were discussed. And so far as the related issues are concerned, you will find that in this, no doubt, apart from that, there are other cases. uh, I have to complete within 20 minutes or 25 minutes, and I have to also cover uh, this Article 29 and 30, that is very, very important cultural and educational right. And just in brief, I will tell about this Article 26 and 27, that is the article clearly says freedom to, just we switch over to this Article 26, which says about is freedom to manage religious affairs. This is actually, you will find that Article 25, which says about an individual's right, but actually Article 26 protects collective freedom. That's why there is the word is itself indicating freedom to manage religious affairs. So, according to Article 26, every religious denomination or any of its sections shall have the certain rights. You will find that a right to establish and maintain institutions for religious and charitable purposes, a right to manage its own affairs in the matters of religion, right to own and acquire movable and immovable property, and right to administer such property in accordance with law. So this all aspects which has been mentioned in Article 26, which is talking about to manage the religious affairs. Just you will find among Hindus, among Muslims, there are a number of these religious affairs which is managed by that particular group of persons. And like among Muslims, you'll find madrasas are there. There is also concept among Hindus where a particular type of religious education is imparted. So this Article 25, which we have discussed, actually is a rights of individuals, while this article which we are discussing is of religious denomination of their sections, or it can be called, in other words, we may call it is a collective freedom of religion. So No doubt, this Article 26 is also subject to public order, morality, health, which is also there. And when you will see that article, so far as the Article 26 is concerned, which is talking about the this religious affairs. So this all religious institution and affairs with regard to the affairs pertaining to the issue of religion and to acquire movable and immovable property. Actually, this is also giving the right to manage the all religious related activities affairs. Then you have all the right. There is also which is also touching when we will discuss the when we will discuss cultural and educational right. Then we will discuss few important cases like Aziz Basha and other related case, which slightly is touching freedom of to manage and religious affairs aspect, that you have all the right to administer the property owned by that particular denomination, and this right is actually a collective right which is available actually to fulfill this, to actually enjoy the freedom of, so far as the freedom of religion is concerned. And this Article 27, which talks about uh, freedom from taxes for promotion of any particular religion, which provides that no person shall be compelled to pay any tax for the promotion or maintenance of any particular religion or religious denomination. So this article emphasizes the secular character of the state, and it says that public money collected by way of tax cannot be spent by the state for the promotion of a particular religion. And you will find that uh, this article is also very important actually to avail in true sense so far as a right to freedom of religion is concerned. And but there are certain restrictions which has also been imposed so far as these all rights are concerned. And due to that reason, you will find the another article which is saying that you have the right to uh, uh, they establish the religious institutions. But if it is such state-aided institutions are there, so obviously there is a prohibition that you cannot uh, think for, you cannot disseminate, you cannot uh, how do you call it, the religious instruction cannot be imparted in that institution. Meaning thereby, uh, as the another part of this, when we will see this all these threats, that Article 28 of this constitution, which says that I have said that freedom, 26, which clearly says about that you can establish the any, or you can maintain institution of religious or charitable purposes. But if the any institution which is state aided, you cannot think for religious instruction. And that's why it has been mentioned that no religious instruction shall be imparted in any educational institution wholly maintained out of a state funds. And you will find that in Article 28, which says about uh, certain aspects pertaining to the, which is talking about the religious this institution. So actually, when you will demarcate, you will find that this Article 28 says about certain varieties of institutions, certain kinds of institutions, like institutions which is wholly maintained by the state, or which is recognized by the state, or which is receiving aid out of the state fund, or which there may be another type of institutions that are administered by the state, that are established under any trust fund. In the first category, only maintained by the state, you cannot think, or no religious instruction can be imparted. And in category second and third category, religious instruction may be imparted only with the consent of the individuals, or uh, in the type, the fourth type, there is no restriction on religious instruction because it is coming under the any particular trust, or you may call it any endowment, and which is for a particular purposes. So the religious education can be imparted in that institute. So these cumulatives, uh, Article 25, and this all are the offshoot of this freedom of religion, that is to manage the religious affairs, as well as to freedom of taxation from the promotion of religion, freedom for attending religious instruction. These all are actually the offshoot. Further, it can be called, it is the elaboration or the further expansion, it may be called. We call it actually in two sense. This freedom of religion can be availed, but subject to certain restriction which has been uh, mentioned, and which is in the clause itself, which has been mentioned, must be that will be there. So it can be, but subject to certain limitations. But I will not go in detail with regard to this 28 more 27 due to the reason of this positive time. Only 20 minutes are left. But this is very important, which I want to highlight here. That is cultural and educational. The question comes: ki this right is available to minorities only, and the question arises: who is coming under the purview of minority? Do you know who comes under the purview of minority? Minority किसे कहते हैं? मैं एक तरफ से बोलता ही जा रहा हूँ. Who is minority? Anyone can give the answer. Actually, this term minority. First of all, this question comes in this cultural and educational rights that this has been given to minority, and that is commonly it is thought, but actually it is not like that. No doubt, this has been given to persons, to a group of persons who are, uh, no doubt, it is for the protection of the interest of the minorities. So when we see the act, what is the language of act? This Article 29 and 30, it talks about first Article 29, which talks about the protection of the interest of the minorities, and Article 30, which talks about the right of minorities to establish and administer the educational institutions. This Article 29 says that any person, any section of the citizens residing in any part of India having a distinct language, script, or culture, the three things are there: language, script, and culture of its own, shall have the right to conserve the same. And it further says, the another portion is said, that no citizen shall into any educational institutions maintained by the state or receiving aid out of the state funds on grounds only of religion, race, caste, or language. So the first part, the first provision actually protects the right of a group, and so far as the second part is concerned, the second provision guarantees the right of a citizen as an individual, irrespective of the community to which की बात कर रहे हैं. This Article 29 actually it provides protection to both religious minorities as well as linguistic minorities. So religious minorities may not only Muslim, Sikh, this Jains, they all are coming, and linguistic minorities may be number. So you will find that so far as the Article 29 and 30 is concerned, that Article 29 is protecting, which is talking about the interest of the minorities, uh, who is on the basis, which is on the basis of, which has been mentioned, language, script, and culture. On the basis of language, there may be a person may be in minorities. And this term, which is generally comes to your mind, there is no any specific definition of the term minorities. It is actually determined on the basis of demographic composition. Because in Kashmir, Hindus are in minorities. In certain you will say northeast part, Hindus are in minorities. Christians are in majority. Few districts you will find that maybe Muslims are in majority, Hindus are in minority. So obviously it depends upon the different states, and within the different states, uh, what is the population of a particular community. So this 29, which is talking about to protect, is providing protection to certain groups, a particular group of persons who are distinct, they have their distinct language, script, or culture. But here the Article 30, which is actually saying about that, which says that all minorities shall have right to establish and administer educational institutions of their choice. Meaning that by this Article 30, which is talking about that you have the right to administer, you have the right to establish and administer educational institution of your own choice. Actually, this right which has been conferred in this clause is of two types of minorities: religious and educational, linguistic minorities, and the right conferred, which says about the word establish, which indicates to bring into, we may call it to bring into the existence, you can establish it. And the right to administer means that in what way uh, you can effectively manage and conduct the affairs of the institution. So the administration connotes the management of the affairs of the institution. And obviously the management must be free of control, so that the founders of that community can run it, the institution, whatever the way they want, if things fit the institution, for what purpose they have established a particular institution. And in this regard, there are few very important cases where these aspects of this educational rights, this Article 30, especially that this has been elaborated. And in this particular case, in this particular issue, there are a number of cases, but three important cases we will discuss. That is TMA Pai Foundation case, Aziz Basha case. Actually, this in Aziz Basha case, you will find that there are also cases where the court has denied that a legal Muslim university, that is also the issue of a legal Muslim university, whether it is a minority institution, or you may call it the later on case of Naresh Agarwal case, where this that is also a case of related to a legal Muslim university, whether it is a minority institution or not. So these three cases we will discuss, by which we can understand this, specifically that is with regard to Article 30 of the. Actually, in this Aziz, first of all, this Aziz Basha case, actually, versus has held this case that a legal Muslim ministry was not established by the Muslim minority, and therefore it could not claim the right to maintain, because it was established under the statute which was passed by the parliament. Actually, this AMU was passed by the this came into this ministry came into existence by the Act of 1920. So it is not a minority. It is not a institution, a minority institution, and there cannot be this ministry cannot claim that they have the right to maintain that governing body, the governing authorities cannot claim. So, meaning thereby, it could not claim the right to maintain. But before going to that very landmark case, that is a TMA Pi Foundation versus State of Kerala, Constitutional Bench of Judges of the Supreme Court has held by a majority that the state governments and the universities cannot regulate the admission policy of unaided educational institutions run by linguistic and religious minorities. But state governments and universities can specify academic qualifications. Your question is that the judgment of Muhammad Hanif Qureshi is a judgment delivered upon religious sentiments majorly, and religious sentiment is antithesis to religious beliefs, which is struck settlement. So, can we say the Supreme Court has? So, I just let me complete with only 5 minutes, then I will give the answer. I will try to give the answer. So, मैं उसको बस 5 मिनट में complete करूँ. टॉपिक बहुत थे. It was really very tough for me to complete all this. So, in this particular case, it was said by the court that state governments and universities can specify academic qualifications for a student and make rules and regulations for maintaining academic standards. The same principle applies in the appointment of teacher and other staffs. An unaided minority educational institution would be free to hire as it pleased as long as some essential qualifications were adhered to. So in this particular case, this in very in a very broader way, these all aspects that monetization, which are unaided and other issues, and we actually this in this particular case regarding the admission there and there to regulate it, these all questions were there, and you will find that this TMA 5 Foundation that actually the number of petitions were filed by the management of minority education institutions challenging the unnecessary control exercised by government through various rules and regulations and hampering their progress of quality education. That was their contention. And they contended that the right enshrined in Article 31, Clause 31, due to the use of this phrase of their choice, give them full autonomy in running their institutions. And in all, the court framed 5 questions that was considered, and that is the question was that what is the extent of control of state on minority institution? What should be the procedure for admissions of students? Whether the eligibility will be confined to minority students or students of other communities, and who is minority and how it is to be determined, whether these rights are available to minorities only or to other communities. There are a number of questions which are asked. So this question is this is a very important case law with regard to this issue. But actually, by this case also, this issue couldn't be solved with regard to this uh, all aspect pertaining to the control and other issues, and which was no doubt and discussed in very in a very deeply. It was analyzed by the court with regard to all the this management and their affairs and how the education is going to be controlled. Actually, no doubt. Number of issues were discussed in this particular case. So just I conclude because I have only for 15 minutes. The last case, that is of Naresh Agarwal case, that is the case of 2005. And actually, in this case is of 2005, and case is a very important case in this regard. Uh, the reason is that the question came before the court, Allahabad High Court, that whether Aligarh Muslim University is a minority institution or not. Actually, this when a student was denied to take admission uh, due to the reason, and he took the plea due to the reason of religion. Actually, that student was medical in a medical course, and he was denied to take admission in PG course in the session of 2005 and 6, and that student has challenged the validity of the rule which were framed that how which, the admission is going to take place. So the rule declared that the AMU in a minority institution and allowed 50% reservation to Muslim students. But uh, but the Allahabad High Court held that AMU was not a minority institution, and the court struck down the amendment made, which was with regard to the reservation for Muslim students. And the court has actually followed the Aziz Basha's case, that is Aziz Basha versus Union of India, wherein the Supreme Court has held that Aligarh Muslim University was established by an act of parliament, not by Muslims. Although the matter is before the Honorable Supreme Court has just is pending, in which has not been finally decided till now that AMU is a minority institution or not. But uh, Allahabad High Court has struck down the policies with regard to admission of the students on the basis on a particular basis that 50% reservation will be for the minorities. So this is in very brief with regard to this cultural education, right? No doubt there are it will take more time to go in, but due to the positive sign, I have tried at my level best to conclude within the specific time. Now the question, because we have 13-14 minutes. First question is, should I take the questions, Gautam?
Yes, sir, sure, sir, you can.
First question is, the judgment of Muhammad Hanif Quraishi is a judgment delivered upon religious sentiments majorly. Religious sentiment is antithesis to religious. So can we see the Supreme Court has held by delivering this judgment? Actually, in the Hanif Quraishi case, actually, you will find that whether any particular rituals, any particular act is performed during any particular festival on any occasion, the court has seen whether it is the integral part of that religion, which is the basic tenets of it. Actually, it is not. And the court was right that to slaughter of cow is not an integral part. And without that, a rituals cannot be performed. It is not so. So Justice Qureshi in this particular case has rightly observed. And you will find that because the birthplace of the Islam is not India, its birthplace is Saudi Arabia. And you will find that in the instruction or in the holy book, this terminology that you will have to go for cow slaughter like that, it is not there, as well as it is not mandatory. It is only mandatory for few persons who are well off, then they can do it. It is not compulsory for all who they will have to go for slaughter. So it is not an integral part. It is not basic tenets of Islam. That it is not mandatory in nature. So to go for cow slaughter is not mandatory. That's why it is that this contention was. What is the next question? The statutory regulation of educational standards and condition of employment in minority education institutions, how it hampers society. Actually, you will find that the minority institution have their own system, and no doubt it is unfettered that whatever what you can do, it is not like that. Like example of Aligarh Muslim University, Jamia Millia Islamia, there are other Christian minority institutions. So the statutory, they have their own regulation, but it should be within a particular broader ambit of guidelines. Like for the appointment of teachers, definitely they have to be governed by the UGC regulation. What is the UGC guideline is there? That a teacher must fulfill this criteria, or like the admission of the students. So certain this liberty is there, but under the within a particular periphery. So it no doubt, and the purpose is to for the upliftment or for the protection of their culture, and that's why their script, their language, 29 and 30 has been given, and for protection of that, they can establish the institutions where they can promote their language, their culture that can be protected. So it not we call it that it hampers the society in that way. Rather, this right has been given for the protection, and which is very works very positively for all the minorities, irrespective either on the basis of religion or on the basis of language. So आप यही पूछना चाह रहे हैं अगली नौकरी में कि statutory regulation of educational standards and condition of employment in minority educational institution, how it hampers society. जहां तक मैं आपके क्वेश्चन को समझ पा रहा हूँ, you are asking in that Shivanshu Mishra, what you are asking, Article 26. Actually, this Article 26, yes, I'm telling you. That Article 26, which is talking about that, which is saying about, थोड़ा सा इसको मैं short में I have done it, but okay. Article 26, which talks about this to freedom to manage religious affairs. Actually, this particular article which says, which is giving liberty that so far as the these religious affairs are concerned, actually it is talking about this Article 26, 26, which is talking that any religious denomination or any of its section which have certain rights. Here you can call it the denomination. This term is which has been used in that context is actually when you will see the general meaning of this term, so you will find that this denomination which says that actually a particular in a very you may call it I will explain with the help of example that how it comes, and if you will see the literal meaning, you will find that it is a particular recognized autonomous branch, or you may call it uh, a particular type or a nature. So that has been mentioned in Article 26, which is actually talking about that when you will see the inner part of that particular articles that says that of any religious denomination of any type, you will find they have the right to establish and maintain institution for religious and charitable purposes, and you have the right to manage your own affairs, and you have right to own and acquire movable and immobile property, and you have right to administer such property in accordance with law. For this the purpose of this religious affairs, this which is coming under the purview of freedom of religion, any religious you may call it any religious denomination, uh, they have the right that they can do all the works pertaining to that, which will actually give you in real sense uh, uh, in practical parlance how this right to freedom of religion can be achieved and it can be enjoyed. Or any other question I said? किसी ने और क्वेश्चन पूछा है? I
गौतम
think I have the I think I am done.
So, students, if you have any more question, you can ask. So, meanwhile, I have a more or less opinion, or I will seek comment on that. It's not a question, but so like in 26 itself, we discussed, and you also repeated that while clarifying to some of a question that every religious denomination or say every religious institution has the right to manage its own affair
आपकी
in matters.
आवाज थोड़ी सी आवाज आपकी धीरे आ रही है। ठीक है, फिर प्लीज हाँ स्पीक।
Sir, I'm asking ki, in under Article 26, the clause B allows any religious institution or affair that you are entitled to manage your own affairs. And sir, in recent past, you must have heard, or the people reading the newspaper must are aware that certain time the state government or the central government passes such legislation to take control of the management or administration, like happened in Uttarakhand, like there is act in Odisha, or there is a special legislation in Tamil Nadu or Kerala for the management of the governance mechanism. So, do these act somewhere conflict to the provision of 26B, or are there exceptions so that they are allowed or
दिस
they
इज अ
are
वेरी
being
गुड
legislated?
क्वेश्चन।
So what's the balance?
जहाँ तक मैं आपकी आवाज सुन पाया, लास्ट की चीज लाइन नहीं सुन पाया। एक्चुअली गवर्नमेंट इज इंटरफेयरिंग, एक्चुअली इट इज वैलिड, और इसे हम इंटरफेरेंस नहीं कहेंगे। वेयर the question is that you have the freedom, but it does not mean this freedom is unfettered. There is no any we may call it there is no any or there is no any mechanism by which it can be taken into account.
खत्म लग रहा है, सर की आवाज नहीं आई क्या?
No, sir.
नो सर, कहाँ से? यू आर नॉट ऑडिबल।
ये लास्ट टाइम आवाज
हाँ सर, अब आ रही है थोड़ी।
ये आवाज आ रही है, जा रही है। आई एम नॉट।
सर अब आ रही है थोड़ी सी।
एम आई ऑडिबल? आवाज आ रही है?
सर गौतम,
Yes, sir.
मेरे आवाज में कुछ प्रॉब्लम है। चलो फिर देख लेते हैं, बाद में देख लेंगे, क्वेश्चन खत्म करते हैं। टाइम भी हो गया और आवाज की भी इशू है।
Okay, sir. No issues. No issues. So let me conclude the session. That thank you so much, Afkar sir, for finding out or devoting some time for the lecture with us. It was really very informative. You covered in depth the case laws, the provisions of the Constitution, the other provisions of the Bare Acts which are available, which the Constitution provides for. So thank you so much, sir. You also clarified many aspects of religious practices, whether they are considered as essential practice. Sometimes the people of the non-religion belonging to them consider that to be essential practice, but you very beautifully articulated on that aspect too. So thank you so much, sir. Thanks a lot. And students, we will meet next week.
Okay. Thank you, everyone. Thank you, Gautam. Thank you, Afkar sir.
Thank you, sir. Thank you.
Okay. Bye.
हाँ यार, thank you. Thank you.